Pills, powders, and presumptions. Few areas of criminal law create more confusion, fear, and unintended consequences than drug enforcement. A firearm is usually recognizable. A stolen vehicle is usually identifiable. A forged check can be examined. But a white pill? A small plastic bag containing powder? A handful of tablets in a pocket organizer? Those situations often involve uncertainty. Yet arrests frequently occur long before certainty arrives. The result is a difficult tension between legitimate public safety concerns and the constitutional principle that guilt should be proven rather than presumed. This chapter examines that tension. The prescription that became contraband. Imagine an entirely ordinary situation. A 65-year-old diabetic carries blood pressure medication, pain medication, and several vitamins in a weekly pill organizer purchased at a pharmacy. The original bottles remain at home. The person is stopped for speeding. An officer notices loose pills. Questions begin. What are they? Who prescribed them? Where is the bottle? Can ownership be proven? For many Americans, this scenario would seem harmless. Under Georgia law, however, possession of certain prescription medications outside their original pharmacy container can itself create legal problems, particularly for controlled substances and dangerous drugs. Georgia law generally requires such medications to remain in their original labeled containers unless a statutory exception applies. Many citizens are unaware of this requirement. Many elderly citizens routinely use pill organizers. Many caregivers separate medications into daily doses. Convenience and compliance with medical treatment can unexpectedly collide with criminal statutes. Why original containers matter? Lawmakers did not create these rules arbitrarily. Original containers provide important information: patient name, prescribing physician, drug name, dosage, prescription number, pharmacy information, date dispensed. The label can quickly establish lawful possession. Without that information, officers may be unable to distinguish between lawful medication and unlawful possession. From an enforcement perspective, the rule has practical value. From the citizen's perspective, however, the consequences can seem harsh when no criminal intent exists. The grandmother using a pill organizer does not necessarily resemble the drug trafficker transporting narcotics. The statute may apply to both. The law sometimes struggles with nuance. The pill that looks like another pill. Modern pharmaceuticals create another challenge. Many pills look remarkably similar. A legitimate prescription tablet may resemble an illicit drug. An over-the-counter medication may resemble a controlled substance. A vitamin may resemble an opioid. A dietary supplement may resemble a benzodiazepine. Even trained professionals frequently rely upon markings, databases, laboratory equipment, and manufacturer records to identify medications accurately. Visual identification alone is often unreliable. Researchers studying pharmaceutical identification have repeatedly found that pills with different ingredients may share remarkably similar appearance characteristics. The eye can be deceived. Chemistry is harder to fool. Probable cause versus proof. This distinction lies at the heart of countless drug prosecutions. Police officers require probable cause to make arrests. Prosecutors require proof beyond a reasonable doubt to secure convictions. Those standards are not the same. An officer who reasonably believes a substance may be illegal can sometimes lawfully make an arrest even if later laboratory testing proves otherwise. The law recognizes that officers often make decisions under uncertain conditions. The accused person experiences something different. The handcuffs feel real. The jail is real. The bond payment is real. The job loss is real. The later dismissal may be real as well. But the consequences of the arrest occurred first. Field tests and their limitations. For decades, law enforcement agencies have used presumptive field drug tests. These tests are generally inexpensive, portable, and quick. Many operate by introducing chemicals that produce color changes when exposed to certain categories of substances. The tests serve a useful investigative purpose. They also have limitations. A presumptive test is exactly what its name suggests, presumptive. It indicates possibility rather than certainty. Colorimetric field tests may identify chemical groups rather than specific drugs and can produce false positives under some conditions. Confirmatory laboratory analysis remains the gold standard for forensic identification. This distinction is critical. Presumptive tests help begin investigations. Laboratory tests help conclude them. When science arrives too late, suppose laboratory testing eventually proves the substance was not illegal. The charges may be dismissed. The prosecution may end. The constitutional system worked. Or did it? The accused person may already have lost employment, missed rent payments, lost child custody time, paid bond fees, paid towing charges, appeared in booking photographs, lost professional licenses, suffered reputational damage. The laboratory corrected the legal record. The laboratory could not restore time. This is one of the central themes of criminal justice reform. When innocence arrives months later, some punishments have already been served. The national debate over field testing concerns regarding presumptive drug tests have become increasingly visible across the country. Researchers and legal reform advocates have documented cases involving false positives and mistaken identifications resulting from inexpensive roadside testing methods. Some jurisdictions have begun limiting the use of field test results as the sole basis for detention or prosecution. In 2026, Colorado enacted reforms intended to reduce the risk of wrongful arrests based solely upon preliminary field tests and to encourage confirmatory laboratory testing before major legal consequences occur. Supporters argue such reforms protect innocent people. Critics argue that requiring laboratory confirmation before arrest could hinder enforcement efforts. The debate continues. The war on drugs and the expansion of criminal liability. Beginning in the 1970s and accelerating during the 1980s and 1990s, the national war on drugs dramatically increased criminal penalties associated with controlled substances. Many supporters believed harsh penalties would reduce addiction and drug trafficking. Some successes occurred. Large trafficking organizations were disrupted. Certain dangerous substances became harder to obtain. Drug-related violence occasionally declined in targeted areas. Critics point to other outcomes: prison overcrowding, disproportionate impacts on poor communities, increased incarceration rates, long-term employment barriers, family disruption. Reasonable people continue to disagree regarding the balance of costs and benefits. The historical impact is undeniable. Drug policy transformed the American criminal justice system. Georgia's prescription monitoring program. Georgia has attempted to address some forms of prescription misuse through data rather than incarceration alone. The state's prescription drug monitoring program tracks the dispensing of Schedule II through Schedule V controlled substances and provides physicians and pharmacists with additional information regarding prescribing patterns and potential abuse concerns. Supporters argue the system helps identify dangerous prescribing behavior and doctor shopping. Critics raise concerns regarding privacy and the expansion of surveillance. As with many criminal justice issues, technology creates both opportunities and concerns. Hall County as a local lens, Hall County faces many of the same challenges confronting communities nationwide. Physicians prescribe legitimate medications. Pharmacists dispense controlled substances. Patients manage chronic pain, anxiety disorders, cancer treatment, post-surgical recovery, and other medical conditions. At the same time, law enforcement agencies encounter illegal trafficking, counterfeit pills, fentanyl contamination, and dangerous synthetic opioids. These realities coexist. The challenge is distinguishing one from the other. The grandmother with a pill organizer and the trafficker transporting counterfeit fentanyl tablets represent entirely different public safety concerns. The legal system performs best when it recognizes the difference. Counterfeit pharmaceuticals and a new threat, the emergence of counterfeit pills, has complicated enforcement even further. Criminal organizations increasingly manufacture pills designed to resemble legitimate medications while containing fentanyl or other dangerous substances. A tablet marked to resemble a prescription painkiller may contain entirely different ingredients. The appearance of legitimacy becomes part of the deception. This reality strengthens arguments for laboratory analysis and professional identification rather than assumptions based solely upon appearance. In drug enforcement, appearance can kill. Appearance can also wrongly accuse. The pressure to plead drug cases expose another difficult reality. Most criminal cases in the United States never reach trial. They end through plea agreements. A defendant facing months in jail awaiting laboratory results may be offered immediate release in exchange for a guilty plea to a lesser charge. Even innocent defendants sometimes face enormous pressure. Remain in jail waiting for science. Or go home today by accepting the plea. The constitutional system assumes rational decision-making. Human beings under stress often make survival decisions instead. This does not mean innocent people routinely pled guilty. It does mean the incentives deserve examination. Evidence before assumptions. Drug enforcement presents genuine dangers. Fentanyl kills thousands of Americans annually. Trafficking organizations generate violence and addiction. Communities deserve protection. At the same time, constitutional principles remain important precisely when fear is greatest. The temptation to assume guilt grows stronger when drugs are involved. That temptation must be resisted. The white powder should be tested. The pill should be analyzed. The evidence should be examined. The Constitution does not require certainty before investigation begins. It does require proof before punishment ends. The presumption that matters most at the center of every criminal case lies a simple principle: the burden belongs to the government. Not to the accused. Not to the family. Not to the employer. Not to the community. The government alleges. The government proves. The defendant responds. That sequence matters. When suspicion becomes guilt before science speaks, the presumption of innocence begins to disappear. The founders of the American system understood something essential: liberty survives only when evidence outranks assumption. The next chapter examines a related question that sits at the center of countless criminal prosecutions. What happens when evidence is seized but never fully analyzed, and when discovery reveals what investigators never tested at all? Global Robotics Corporation. Robert Colee.